Ohio. Ms. Tranter.
Your Honor, my understanding is that Mr. McLean is going to be changing his plea to count 1 and count 2 of the indictment. Both counts are assault on a police officer, felony of the 4th degree. State will be asking for dismissal of the remainder of the indictment.
All right, Mr. Madden, is that accurate?
Yes, sir.
Okay, Mr. McLean, you're telling me that you're going to change your plea to guilty to 2 counts from the indictment. Before I get to your change of plea, I'm required to go over some things with you, okay, sir?
Yes, sir.
How old are you?
I'll be 63 the next week.
How far did you go in school?
I went to 10th grade, but I took a vocational school activity too. I may have graduated. I'm not positive about that.
Okay. Can you read and write okay?
Yes, I can.
Are you
I have dyslexia, so the reading part of it is somewhat of a problem. I actually read somewhat upside down and backwards.
Okay.
And I can read the right way because that's the way I went through school.
Okay. Are you a citizen of the United States?
Yes, sir, I am.
Has anyone promised you how the court would sentence you in this case?
No, sir, they haven't.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you received from Mr. Madden?
Yes, sir, I am.
Are you currently under the influence of any drugs or alcohol?
No, I am taking a mood stabilizer, which they've offered me through the jail system.
Okay. Do you take any type of medication that interferes with your ability to understand what's going on today?
No, sir. I was on lithium since 2004 and Respidone. The Respidone I was weaned off of and taken off of, and the lithium I was still on up till my incarceration.
All right. I have in front of me a document. It's called a change of plea. On the second page of this document, on the line marked defendant, there appears a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
I went over it with my attorney, yes, sir.
Do you feel like you understand what it says?
Yes, sir.
Okay. This document says you're entering a plea of guilty to 2 counts of an assault on police officer. Each of those carries a maximum penalty of 18 months in prison, and each of them carries a maximum penalty of $5,000. The prison sentences are not mandatory. Do you understand the maximum penalties involved?
Yes, sir, I do.
In addition to those maximum penalties, you're also subject to a discretionary period of post-release control. And what that means is that if you are sent to prison, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
But it's not mandatory that you're sent to prison at all. The court does have discretion to place you into community control, or what some refer to as probation. While on community control, you'll have rules you must follow. If you fail to follow those rules, the court has the authority to extend the term of your community control or to impose additional, more severe sanctions, which can include local jail time or prison. Do you understand that?
Yes, sir.
You are presumed innocent of these charges. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
Yes, sir.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of your attorney, you have the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
Yes, sir.
You have the right to remain present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt, and that standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you
Could I say
believe-
one thing on my behalf?
In a second.
Okay.
Do you believe that you understand each of these constitutional rights that we've gone over?
Yes, sir.
And you understand that when you enter a plea of guilty, You'll be waiving all these rights. We will not have a trial.
I don't understand that also, sir.
That's how you want to proceed.
Yes, sir.
All right, Ms. Tranter?
Your Honor, both of these incidents occurred March the 7th, 2026, Warren County, State of Ohio. On that date, the defendant did knowingly cause or attempt to cause physical harm to another, being two separate police officers from Franklin Police Department. This occurred during a struggle during an incident where they were attempting to place him under arrest.
Mr. Madden, anything on those facts?
No, sir.
Mr. McLean, did you hear the statement that she read?
Yes, sir, I did.
Do you admit that what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up by entering a plea of guilty, the
Yes,
rights
sir.
we discussed. What's your plea?
It's guilty
All right.
by reason of insanity.
No, it doesn't work that way.
Well, that's what it was presented to me as.
No, what we did was, and what Mr. Madden did, is that he filed a motion, or he filed a written not guilty plea by reason of insanity. We have a report here, which we've already received from the I don't want to call it an assessment, but the interview from the psychologist
Yes, sir.
says that you were not NGRI.
Okay.
So your choices now are, we can go to trial, which is one of your constitutional rights, to have your case heard by a jury of 12 people, or by me, and have the state prove each and every element of the offenses from the indictment beyond a reasonable doubt. That's one option. The other option is what we're doing right now is
That's what I'm going with, is what my lawyer presented me with today.
okay, this is a plea of guilty then
Yes,
to
sir.
these two charges. Is that what your plea is?
Yes, sir.
All right. Court's going to make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. Court will accept your plea of guilty, and based upon the statement of facts that was read and your plea of guilty, I'm going to find you guilty. Now, I'm not going to sentence you today. I'm going to order a pre-sentence investigation, and we will come back, and I will do sentencing when I know more about you. Okay, sir?
Okay.
All right,
Yes, sir.
thank you.
Thank you.
You can have a seat over there.
Your Honor, is there any thought about whether or not to allow him to go out to be released pending the sentencing?
Not without a motion, with notice to the victims in the case.
All right, I see.
All right, thank you. Ms. Steinmetz?
Everyone in the courtroom expected a routine guilty plea until the defendant suddenly said guilty by reason of insanity. The judge immediately stopped him, explaining that's not how the law works. His insanity defense had already been evaluated by a psychologist and rejected, leaving him with only two choices: go to trial or plead guilty. After a brief moment of confusion, the 63-year-old defendant accepted responsibility and pleaded guilty to assaulting two police officers. The judge accepted the plea but postponed sentencing, ordering a full pre-sentence investigation before deciding his punishment. One unexpected sentence completely changed the direction of the hearing.